almost all the copies. I think there is 1 or 2 copies that are there still with me. Otherwise, I have corrected them. See, before actually I start my discussion today, I'll just be discussing the kind of mistakes that you make while writing. Just give me one. I'll be talking about 1 or 2 questions, and I'll be discussing what most of you have written. No, because the questions, the answers that you have written, it is almost similar. Everyone, the questions that I have corrected, the answers are almost similar. Like there is a question that I asked. The question was, preamble is the philosophical key to the Constitution. The statement was, preamble is the philosophical key to the Constitution. Examine. See, most of you have written the same answer, wherein you have provided that there are some values that we had discussed, and you have written about those values. You have written about those values like, okay, sovereign, socialist, secular, democratic, republic. You have explained this. But see, the question was about one key phenomena, the key idea, that is philosophical key. And no one has explained this idea of why it is a philosophical key. No one. See, was the question about values of the preamble? No. The question was, why is it a philosophical key? And though the answer would revolve around the values, wherein you are going to write the values and then going to explain the next part of the question, philosophical key. And most of you have written about the values. Most of you. And you have done that in all the questions. The second question was, preamble contains the aims and aspirations of the Constitution. Explain those aims. Aims and aspirations of the Constitution, explain those aims. See, for this question, I understand if you write values. I understand the idea that if you write values, and I will assume that if you have written values, what you are trying to write is about the aims and aspirations. I'll understand that. So I'll take the same answer wherein you have written values. I will take that answer as, okay, fine, this is the answer to this particular question. Similarly, the third question was, the edifice of our Constitution is based upon the basic elements in the preamble. The edifice of our Constitution is based on the basic element of the preamble, element in the preamble. What is the meaning of the term edifice? Yes? Yes? Domain? No. Yes? It is somewhere similar to the structure, but the term edifice means pillar. It means pillar. So if you replace the term edifice with pillar, the pillar of our Constitution is based on the basic elements in the preamble. If any of those elements are removed, the structure will not survive, and it will not be the same Constitution and will not be able to maintain its identity. Now see, these are 3 questions, and most of you have written the same answer. How can you do that? How can you do that? How can you write the same answer for 3 questions? See, the gist of the question is same, but the demand is to put it in a manner, and that manner is different. The manner in which you actually write them is different, and this is what you have to learn. This is the very reason that this exercise basically takes place. You have to learn not just what to write, but how to write it. What you are focusing upon right now is what to write. You are not considering that there is another important aspect of answer writing, that is the manner in which you write it or the manner in which you present it. Clear? The manner in which you present it. Why it is the philosophical key? So if you are writing the value of secularism, you will always, you will also write why is secularism the philosophical key. You are going to write that you are going to talk about fundamental rights, fundamental right to religion, right to freedom of religion, and you are also going to explain why is that important. Why is that important? Or you can also do this. You can write about some values and in the conclusion, you can explain why it is a philosophical key. No one has done that. Not even one of you. And no one has understood this question. Question number 3. Most of you have not understood this question. Most of you have not understood what is this very question when I say the edifice of our constitution. Now, see, we understand the values, but you also have to write why are those values important. Why are those values important? You have to write why is it that such values, if such values are changed, why is it that our constitution will not survive? No one has written that. Some of you have written the same answer which you have written in question number 1 and 2. Some of you have written it, that in a particular case the Supreme Court has declared it as a part of basic structure of the constitution. That's it. That's it. No one has explained why is these values so important that if we fundamentally change or if in any way we tamper with these values, the Constitution of India will not survive or it will not have the same kind of integrity that it has as of today. No one has explained this idea. Clear? So what I want is that from the next test or the second test that had happened, that was there, the second test, though it had some questions, third test was mostly, it was all about your multiple choice question. This test I had included most of the multiple choice questions and some of subjective was also there. Now I'm going to correct this, but what I want you to do is from the next test onwards, or for those whoever has written this, and when I check it and give it to you, just see the mistake that you have made. Go through the question once again and read the answer. Read the answer, what you have written. Get into an habit of when you are reading the question, underline the key words in the question. Underline the key words. And in your initial days of writing answers, you should be in a practice of reading the question again and again. That means once you have read the question, you have written suppose the introduction, read it again. Because once you read it again, that any kind of, what we tend to do is we tend to modify question based on what we know. Once we have read it, okay, now we know that, okay, this is the question. Once we have written the introduction, we will modify what is being asked on the basis of what we know. This practice is something that is absolutely wrong. So what I want is, after you have written the introduction, go through the question once again and then write the main aspect, that is the body of the question. And after you have completed that, go through it again and then summarize, or what you can say, conclusion. And you have to work hard a lot when it comes to writing conclusions, because most of you tend to do what? Most of you tend to summarize your answer in conclusions. You are wasting words. Why is there a need to write a summary in a conclusion? Whatever you have written in body, you are trying to summarize it in conclusion. Why is there a need to do that? When you have suppose 30, 40, 50 words remaining, why don't you use it more innovatively? Use it more innovative. When I say innovative, don't become extraordinary innovative, but at least you should become innovative enough. Don't then just writing summary of the body, that will not make any sense. Clear? So there is a need for you to work hard when it comes to writing conclusions. Sometimes you can write conclusions on this basis, giving an alternative. Whatever has been presented in the question, give a suggestion or an alternative. Write a contrary opinion of what you have written in the body. All these things can be done to write a better conclusion. Don't just summarize what you have written in the body. That is, you will find out of around 15,000 aspirants appearing for mains examination, more than 12,000 will do that. They will try and summarize whatever you have written in the body. And that is the reason why these 12,000 will not get through. These 12,000 will not get through. Why? Because the examiner, as an examiner, when I'm correcting it, first of all, I don't have the time to read all of your every letter and every word that you have written. I'll not do that. So as an examiner, first thing that I come across is, okay, what are the things that you have underlined and marked? And now when I read that is my first instinct. I am going to go through that. So whatever important points you have written, you have to be in the mode of underlining it. When I say underline, I don't mean use rang biranga pen. Multiple pen and colors are not needed. You can use a pencil or use the same pen with which you are writing. That's enough. That's enough. Even if you decorate your answer, it does not mean you are going to get good marks. Even if you decorate your answer, it does not mean you are getting good marks. And some of you are you are making examiner, it is for the examiner, it becomes difficult to give you marks. Why? Because you write in such a manner that as soon as I open the answer script, I find, okay, now this is tiring. As soon as I see the script, I find, okay, this is very tiring. Mentally, I am mentally itself, as soon as I see the paper, even if whatever you must have written very good answers, I don't deny that. But mentally itself, I am, pre-exposed to not giving you marks, rather ensuring that you get less and less of marks. This is what happens. This is natural for a human being. So that individual who is correcting your copy there, he is also a human. So he is going to look at these things. I don't want you that obviously, because now you will not be able to change the handwriting that you have. But at least you can write it more clearly. This is what you can do. Write it more clearly. If you suffer from this problem that you don't have a good writing, handwriting, it's bad. In that case, at least give yourself enough opportunity so that the examiner at least reads it. This is something that is going to happen, because see, for an examiner, suppose he is correcting papers, 15,000 individuals have written the mains examination and he is correcting almost all of them. There may be, suppose 10, 15, 20 individuals correcting. Even if there are 20 individuals correcting that particular paper, it means that one individual is correcting more than 500 papers. It's not that his only duty is that he is going to read only your script, nothing else. That is also not the case. Make some very important changes. These are certain changes that you have to make. First of all, read the question. Don't write what you know. Write what is required. Because see, if I am going through a question and I feel that, okay, the question is about philosophical key, but you have written the philosophy, but you are not explaining why it is a philosophical key. See, 50% marks I will deduct at that moment itself, because you have not answered the question. So out of, suppose it is a 20 marker, No, 15 marker. Suppose it is a 15 marker question. That means 7.5. It is deducted then there itself. After that, out of I'll mark out of 7.5, and out of 7.5, if I give 50%, that is an exceptional score. So on an average, you will expect that in one question, if you have not thoroughly answered the question, you are not going to get more than 2 or 3. You are not going to get more than 2 or 3. So out of 20 questions that you have to answer, suppose in a 10 marker, there are basically 2 patterns that are followed. Previously it was 12.5 mark each. Now there is a change in pattern. 10 questions, 10 marks each, and 10 questions, 15 marks each. So if 10 questions, in that 10 question you get 2 out of 10. No, out of 10 you are getting 2. In 10 questions, how many marks are you scoring? You are scoring 20. You are scoring 20 out of 100. And the remaining 150, even if you score 50%, which means at max you are scoring 95. That is if you have exceptionally written the next 10 questions. Exceptional. Which you will not do, because again the last questions that are there, as it is you are in a hurry to complete it, because the paper is not so easy to complete. You have to write 4,000 words. So as it is not easy to complete. So what happens? Out of the remaining 10, 2 questions are there which you don't know the answer to. So you are guessing. ये हो जाएगा, कुछ काम बना लेते हैं. This is what you are doing. Don't expect any marks there. If the examiner feels that you have not written we have not written anything, he gives you 0. It's not कि कोई grace marking चल रहा है. He'll give you 0. So 2 questions, 0. Remaining 8 questions. Remaining are 8 questions, 120 marks. Remaining are 120 marks. So out of that 120 marks, if you get only 30 or 40%, what you get is on an average a score of 60 and 65 out of 250. And what did I say? In the first day I said that average marks that you get in GS paper 2 is less than other papers, and it is somewhere around 60-65. Generally you will find people scoring 60-65. Those who have not qualified mains, they are scoring 60 and 65 here. Why? Because this is the pattern that they write. You are getting 20% marks in each question, wherein you have to get 50%. So rather than scoring 125, you are scoring 60. This is the mistake. Don't write what you know. Write what is demanded. Write what is being demanded. So even I am not saying that after 1 week of whatever we have discussed in the class you will become extraordinary in writing. I don't expect that as well. But at least I expect this much effort from you, that once you are writing this, at least you would know the meaning of the question. Some of you are writing it in this manner, in the manner in which you are writing. I don't feel that you are even understanding the question. नशे में हो बिल्कुल, ठीक है, क्रूड तरीके में ये बोला जाता है, नशे में हो एकदम. आपको लग रहा है कि you have studied preamble, so you know everything about preamble. You know everything about preamble, but what you don't know is the way you have to present it. So you have to learn that. Don't just write answers for the sake of writing answers. This is a very bad habit. Because once you are trained in doing this, it becomes very difficult to change. That you start understanding the question and then writing it. It is very difficult to change. So what you need to do is, whenever you read the question, give it some time. Even if you don't write 20 words, or you are writing, suppose out of 250 words that you have to write, if you are writing suppose 200 words, it has no effect on your marks. If you are qualitatively ensuring that the 200 words that you write, they are qualitatively good. If you ensure this, you are getting In fact, more than those who are writing 250 words. So don't worry about that. Ensure that you are trained. Here itself you are trained in a manner wherein first of all you read the question, you understand the question, and then you write the question. Because see, university pass outs, जो यूनिवर्सिटी में पढ़ते हैं, जनरली उनकी आदत ये होती है, दिस इज द वे यू टेंड टू गो अबाउट राइटिंग आंसर्स. यू सी द क्वेश्चन, you get once you read the question, you mark the word that you know, और फिर कहानी बनाते हैं उसके ऊपर, and you write 3, 4, 5, 6 pages on it. This is not going to work in UPSC. You have to understand the question in full and then write it. Clear? So now and for most of the question papers, most of the answer scripts that I have corrected, I have found the same idea. Same thing. You have done the same thing. It's like correcting the same script again and again. It's like correcting the same script again and again. Okay? Yesterday when I was correcting 2 or 3 scripts, so my son was looking at it. And I felt that if I give him to copy my, whatever remarks I have given, so it will be the same. So he was also going through this. He was also looking at it, and he found that though he is right now not in a position to comprehend what you have written, but no, I thought of once, that I should train him that write this, and if he does that in all script, my work is done, because this is what I found. But theek hai, I am giving you the benefit of doubt. This was only the first script, but don't make it a habit. This is the time wherein you are going to change here. This, once you get in that particular knack of, you are trained here in the knack of first understanding and then writing, then half of your job is done. I'm telling you, half of your job is done. Because if you get the opportunity to write mains, you will get the opportunity to write mains with a certain set of knowledge. That at least you know this much. Until unless you know that much, you are not going to write mains. You are not going to qualify prelims basically. So once you know that, and you are in the knack of writing an answer which is required, 50 to 60% of your job is done. 50 to 60% of your job is done. Why? Because out of the 15 or 12,000 that are writing mains, 50%, not 50%, 75% they are not trained in this. No, they still go by that very idea that see the question, see the word that is there mentioned in the question, and then write about that word. Now that is what they are going to do. So you, as soon as you train yourself in doing this, only this much, wherein you look at the question, understand the question, and write what is demanded, you are already ahead of 75%. You are already ahead of 75%. Which means it's very likely that you are going to qualify mains. You are going to go for that interviews. That is done just by this particular idea. You are going to go for that. Yes, if you improve yourself in the upcoming days, if you improve yourself, it is very likely that your name appears in the list. If you think of it in this manner, then you will find that this examination that is there, it is not that difficult. I'm telling you, it's not that difficult if you know what is to be done. Clear? So always, this exercise that is there, the only reason for it is not training you just to write answers, but also training you to write what is required. In paper 2, you don't get marks. I'm telling you, you are not going to score marks until unless you follow this pattern. Ask any individual who has qualified, prelims more than once, and ask him their score in their paper 2. You will find that those who generally do not get through mains examination, they are scoring very less in the reason. Sometimes it may so happen that this is the reason why they are not able to qualify mains. Why? Because they are scoring 40, 50, 60 in paper 2. And this becomes the reason. You have to score 125 out of 250. That should be your aim. If you score 125 in paper 2 as it is in paper 4 and paper 1, GS paper 4 and GS paper 1, because GS paper 4 50% of it is case studies. And if you are, if you train yourself in writing case studies, you are definitely going to score more than 100 there. It is not a given that you are going to score it, even if you don't read anything. But if you train yourself with minimum effort, you are going to score more than 100 there. Paper 1 is slightly factual in nature. So if you know, you are able to write. So again, more than 100. The remaining is only paper 3. Clear? So just break down your preparation into these things. Think of it in this manner. Even small mistakes that you do, a slight, a bit of mistake that you do, that is very likely to cost you the whole of your attempt. Don't make such mistakes. Rectify it right now itself. And the biggest mistake that you do is this: writing what you know rather than writing what is required. Clear? So start doing that. Whatever paper I am checking, don't just my job of writing because I have written the paper, that's it. Go to your place, read it once again. Keep in mind what I am trying to say right now, and judge it on that basis, and then you will start finding the mistakes that you have made. Clear? Do that. Even for your multiple choice questions, MCQs, when you are when you are seeing your MCQs, anything that you have marked wrong, any question that you have marked wrong, why is it that you were wrong? You need to actually scrutinize it. Because if you have read, suppose, fundamental rights, if you have read directive principles, so if you have read it, why is it that you were wrong? There can be 2 or 3 reasons. First, you have not learnt it. Second of all, it may be that you have not understood the question. Third, though you may understand the question, but sometimes it so happens that in a hurry or something, some kind of mistake that you make. So in this is the time wherein you are going to rectify those mistakes. Otherwise, again, see, whether you get through prelims or not, it is also very much dependent upon this very idea. Because prelims is the first stage. Yes, you will not start your preparation by prelims, but obviously prelims is also a stage which you have to actually cross. It's not that difficult if you have read well, but these mistakes can cost you. So again, the very idea is that. Clear? So we were discussing precedent, and the last part of our discussion was the veto powers of the president. We had discussed the veto powers, we had discussed what is absolute veto, we have discussed what is suspensive veto, we have also discussed what is pocket veto, and we have also discussed something called as qualified veto. Though the Indian president does not have qualified veto, but it is present with the president of US, and how it is different from suspensive veto. Clear? Next, what we start with is our discussion on constitutional position of the president. Constitutional position of the president. Now, listen to me very carefully. First, there are 2 articles that we need to know here. First is Article 53 of the Constitution. What is Article 53 of the Constitution? Did we discuss it in the last class? Yes. The executive powers of the Article 53 of the Constitution says what? It states that the executive power of the Union shall be vested with the President. That means it shall lie in the office of the President, and the President shall exercise such powers in accordance to the Constitution. That means if we solely look at Article 53 of the Constitution, Article 53 of the Constitution declares the President of India to be the executive head of the Union. It explicitly says that it is the President who enjoys all executive powers of the Union. All executive powers of the Union. Now, this raises a question. A question that though the Constitution says that it is the executive, Article 53 of the Constitution declares the President of India to be the executive head. Now in this case, automatically we need to question this very idea that okay, if the President is the executive head, if Article 53 declares the President to be the executive who enjoys all such executive powers. Similarly, there is another article, that is Article 74 of the Constitution. Article 74 of the Constitutional, originally not as of now, originally what did Article 74 say? It said that Article 74 originally it read as, there shall be a council of ministers headed by the Prime Minister to aid and advise the President. To aid and advise the President. The phrase aid and advise is of importance here. Now, with this, along with Article 53 and Article 74 of the Constitution, we also need to understand the relationship that was there between the first president, that is Rajendra Prasad, and the first prime minister, that is Jawaharlal Nehru. See, Dr. Rajendra Prasad was an orthodox by nature. That means his political views were more orthodox in nature, whereas Jawaharlal Nehru was a liberal at heart. He was a liberal. He was a liberal prime minister, whereas the President of India, Rajendra Prasad, was not a liberal. He was an orthodox. If BJP would have existed, then it was very likely that his political opinion was similar to that of BJP rather than that of Congress. Now, Dr. Rajendra Prasad, because of this difference in the political position, one being orthodox and the other being liberal, the relationship between the Prime Minister and the President, frequently led to certain issues. There were some problems with, between their relationship. Like initially itself, when Jawaharlal Nehru, when the first parliament passed something called as Age of Consent Act, they wanted to reform, they wanted to change the age from, at that time, that means in the pre-independence era, which was 4 years. That means it permitted marriage of a child who was 4 years old. Now, Age of Consent deals with that. Child marriages, it deals with child marriages. And in the pre-independence era, the Age of Consent Act, which was 4 years at that particular time, Jawaharlal Nehru wanted, the first council of ministers that were there, they wanted to reform this age, making it from, increasing this age from 4 to 14 years. Rajendra Prasad did not agree to this. Jawaharlal Nehru literally had to force him to sign the Age of Consent Act, wherein he went to the president and said, if you don't sign this act, I am going to resign. And because of the political, the kind of political personality that Jawaharlal Nehru was, Rajendra Prasad was forced to sign it. Rajendra Prasad was forced to sign it. And there were multiple, this is only one occasion. There were multiple such instances wherein the president, the office of the president and the office of the prime minister, they were in a kind of a political deadlock. This led to Rajendra Prasad floating this idea that if you look at the constitution itself, what does the constitution want? Does the constitution allow the president to act by himself? Because the Article 53 of the Constitution gives the executive power to whom? The President, not the Prime Minister. Article 74 of the Constitution says there shall be a Council of Ministers headed by the Prime Minister. But the term that it uses after this is to aid and advise the President. So the question was, can aid and advise ever be binding? The question, the language was such. So the language talked about, no, the language did not say that there shall be a Council of Ministers headed by the Prime Minister and the Prime Minister is going to direct the President. It does not say direct or any such terms. It uses the phrase aid and advise. And the term, these two terms that are there, these two articles, first Article 53, when it was read in exclusion of Article 74, and if you read Article 74 in exclusion of Article 53, this points out that the President may enjoy more powers than the Prime Minister or the Council of Ministers. And that is the reason why the Supreme Court had to intervene and clarify the constitutional position of the President. The Supreme Court in the in these two cases, the Ram Javaya versus the state of Punjab and Shamsher Singh versus the state of Punjab, the Supreme Court clarified the constitutional position of the President. And the Supreme Court said that in India, the Constitution adopts for a parliamentary form of government. And in a parliamentary form of government, the President only enjoys the status of being a head of the state and not the head of the government. The head of the government is the Prime Minister, and the executive authority is not there with the President. Rather, the executive authority lies with the Council of Ministers. It lies with the Council of Ministers. Hence, declaring that it is the Council of Ministers who enjoy more powers. The Supreme Court went ahead and said, that not only is the Council of Ministers the head of executive, but the President of India can do nothing without the advice or against the advice of the Council of Ministers. So the President of India, for the office of the President of India to exist and to work, we require a Council of Ministers. Why? Because the President of India, the office of the President of India can do nothing. Neither can they do anything without or against. So neither can they act in its discretion, neither the office can act in its discretion, neither can they act against the advice of the Council of Ministers, thereby declaring that the President of India is only the constitutional or the ceremonial head of the state, and the real executive powers, though the Article 53 of the Constitution says exclusively, if we read it, we find that it is the President who enjoys such powers. And if we read Article 74 exclusively, we see the phrase aid and advise, which is literally speaking, it cannot be compulsory. How can an advice be compulsory? Okay, if you give me an advice and you say it is compulsory for you to follow, that's not an advice. It is always my discretion whether I act on your advice or not. So if we look at these two articles exclusively, we find that constitutionally speaking, the language says that the President will enjoy much powers. But the Supreme Court said that there is a need to not exclusively read these articles, rather Article 53 of the Constitution should be read in accordance to Article 74 of the Constitution along with Article 74. Now, how can we read this? The executive power of the Union shall be vested with the President, who will exercise such powers in accordance to what the Constitution has to say. And Constitution in Article 74 says that the President will be advised, there will be aid and advice given to the President by the Council of Ministers, and the President will follow such an advice. Though it does not say the President will follow such an advice, however, the Supreme Court clarified, we are a parliamentary form of government, and in a parliamentary form of government, the President is only the head of the state, whereas the executive authority lies with the Council of Ministers. It lies with the Council of Ministers. Further, in the UN Rao versus Indira Gandhi 1971 case, the Supreme Court held that it is a constitutional imperative for the President to have a Council of Ministers. The office of the President, constitutional imperative to have a Council of Ministers, which means even if the Lok Sabha dissolves, there is no more Lok Sabha, the previous Council of Ministers that were there, they are out of office, they are no more in office. They do not enjoy they do not enjoy the majority on the floor of the House. They have lost that majority. Still, they will discharge their duties as the Council of Ministers unless a new Council of Ministers is formed. Why? Because in this case, the Supreme Court declared that it is a constitutional imperative. It is a constitutional imperative for the President to have a Council of Ministers. It becomes a constitutional imperative for the President, which means the office of the President cannot work without the office of the Council of Ministers. And you can see the example of this. The example of this is that very recently in the 2019 general elections, 2019 general elections were conducted, and as soon as, how are general elections conducted? General elections are conducted during the period of elections. The code of conduct is there. No, model code of conduct is imposed. The Council of Ministers are not given the right to take any policy decisions. Nothing of that is done. But the office of Council of Ministers still exists. If you remember, when the election results were declared, when did the Prime Minister, Narendra Modi pitched, the last time when he became the Prime Minister, obviously before assuming the office again, he will have to resign from prime ministership and again take oath. When did he resign? He resigned just a day before taking oath. He did not resign from office the day elections were conducted or when elections were going on. No. He resigned from office just before the day he had to take oath as the prime minister. The council of ministers that were there, they continued in office despite the fact that elections have been announced. Even when the new council of ministers were elected, that means once the Lok Sabha was elected, it was almost decided within the cabinet itself, okay, these are the ones who are going to be allotted such ministries. But they still continued. The previous council of ministers still continued. And just a day before he had to take office, he resigned from office, and the next day he was again administered the oath of office. Why? The office of the president, it is constitutionally imperative for the office of the president to have a council of ministers. It cannot work without the aid and advice that is given, because the constitutional position is very clear. The constitutional position is that the office of the president cannot do anything without or against the advice of the council of ministers. Without the advice or against the advice of the council of ministers. And that is the reason why when the prime minister resigns, or for that matter the prime minister has lost the majority of the house, they still continue to discharge the duties of the prime minister until a new prime minister is appointed or administered oath by the president. He continues to be the prime minister. All the council of ministers continue. That form of government who has lost the majority of the house or no more enjoys the majority of the house, or because the Lok Sabha has dissolved, so the council of ministers no more enjoy the majority, they will still continue in office. That government is called as caretaker government. So an individual who is the prime minister during that particular time, he is called as the caretaker prime minister. And all the other ministers are caretaker ministers. They continue in office. And finally, once the president appoints an individual as the prime minister, now the new prime minister has come to office, a new council of ministers is formed, and again the council of ministers provides aid and advice to the president, and accordingly the office of the president functions. And that is the reason why, if you look at what B.R. Ambedkar had to say, he says B.R. Ambedkar is of the opinion that President of India represents India, does not rule India. He is representing the people of India. The president is representing the people of India, but is not ruling the people of India. Who is ruling? The council of ministers. It is a democratic rule, not the monarchic rule, but democratically it is the council of ministers who are ruling India. President, though, enjoys a position of the executive head, but he is only a ceremonial executive head. The real powers lies with that of the council of ministers. So in India, the position of the president is very similar to the position of the crown in UK, because there also, who is the head of the state? The king is the head, or the crown is the head of the state. The crown remains as the head of the state, but who enjoys the executive powers? The council of ministers, headed by the prime minister. So in India, President of India is an indirectly elected body, but he is only a ceremonial head when it comes to enjoying executive powers. He is the head of the state, but not the head of the government. and hence work on the aid and advice of the Council of Ministers. This aid and advice that is there, that is presented to the Council of Ministers, it is more like mandatory for the President to accept and work or act on the aid and advice of the Council of Ministers. Why? Because Article 74 of the Constitution has been amended twice. First, it was amended by the 42nd Constitutional Amendment. It was amended by the 42nd Constitutional Amendment Act, and the 42nd Constitutional Amendment Act added here. What did it say? There shall be a Council of Ministers headed by the Prime Minister to aid and advise the President. It added, such an advice shall be mandatory on the President, shall be binding on the President. So Indira Gandhi, she was not happy with the decisions of the court, despite the fact that the court took away all the powers that the President may either would have enjoyed, but she amended the Constitution and made it mandatory that any such advice that is given by the Council of Ministers, that is tendered by the Council of Ministers to the President, it becomes mandatory for the President to follow such an advice. However, Article 74 was again amended by the 44th Constitutional Amendment Act in 1978, that is when the Janata Party came to power. So the Janata Party did what? Again amended Article 74, and Article 74 now read that there shall be a Council of Ministers headed by the Prime Minister to aid and advise the President. To aid and advise the President, which the advice can be sent for reconsideration of the Council of Ministers, and after any such reconsideration, generally or otherwise, if the Council of Ministers tender or give the same advice to the President, it becomes binding on the President to act on that advice. Which means currently if you look at the position is that the Council of Ministers would aid and advise the President. If the President is not happy with such an advice, he would send back the advice for the reconsideration of the Council of Ministers. After due reconsideration, if the Council of Ministers tender the same advice, give the same advice to the President, it is mandatory for the President, or it is binding for the President to act on the advice given by the Council of Ministers. Clear? Understood this? Remember Article 361, what did we say? The President and the Governor of the state cannot be punished for the executive actions, the actions that they have taken in executive capacity. Why? Because when they are not acting, when the President is not acting in his discretion, he is acting on the on the advice given by the Council of Ministers. तो ये तो नाइंसाफी है. That you are punishing the individual. If you punish the individual for something which he has not done, or for something which has been, he has been forced to do something, now that is not justice. And that is the reason why Article 361 of the Constitution says the President and the Governor of the state will not be punished for the actions that they have taken in executive capacity. Understood this idea? So what is the constitutional position of the President? He is nominal head, ceremonial head. He is the first, he is the head of the state, not the head of the government. Clear? Understood this idea? Now write this down. Constitutional position of the President. Article 53 states that the executive power of the Union shall be vested in the hands of the President, shall be vested in the hands of the President, who shall discharge his functions in accordance to the provisions of the Constitution, in accordance to the provisions of the Constitution. The Supreme Court, while clarifying the constitutional position of the President, ruled in the Ram Javaya versus the state of Punjab, 1955 case, and Shamsher Singh versus the state of Punjab, 1974 case, that since the Constitution has adapted a parliamentary form of government, the President is the head of the state, but not the head of the government. It is the Prime Minister who heads the government. And the real executive powers of the Union are exercised by the Council of Ministers. The President is only the nominal head. And so long as the Council of Ministers enjoy the confidence of the Lok Sabha, the President is literally bound by the advice of the Council of Ministers. He cannot do anything without the or against the advice of the Council of Ministers. Therefore, Article 53 should always be read along with Article 74 of the Constitution. Next paragraph. In the UN Rao versus Indira Gandhi, 1971 case, the Supreme Court held that it is constitutionally imperative for the President to have a Council of Ministers, even if the Lok Sabha stands dissolved. The Constitution has placed the Council of Ministers, the Constitution has placed the Council of Ministers in the role of an advisor, in the role of an advisor to the President, but in practice, it is the President who advises the Council of Ministers. Next paragraph. Article 74 of the Constitution, Article 74 of the Constitution was amended by the 42nd Constitutional Amendment, by the 42nd Constitutional Amendment in 1976, and it was made constitutionally binding for the President, constitutionally binding for the President to act in accordance to the advice of the Council of Ministers, advice of the Council of Ministers. The 44th Constitutional Amendment, the 44th Constitutional Amendment further amended Article 74, and Article 74 currently reads, there shall be a Council of Ministers, headed by the Prime Minister, to aid and advise the President, comma, the President may require the Council of Ministers, to reconsider either generally or otherwise, and the President shall act in accordance with such advice given after such reconsideration. Next paragraph. Therefore, the President may represent the country. But he does not rule it. His position is similar to the position of the Crown. Under the English Constitution. Clear? Now, there was a question asked, I think it was in 2011. There was a question asked in mains examination. The question, the wordings may be different, the meaning of the question is similar. The powers of the office of the President of India flows in accordance to the powers of Thames rather than Potomac. What does this mean? Potomac basically is a river which passes through Washington, and Thames is a river that passes through London. So the question was basically about the constitutional position of the President, and the question wanted that you write how the President of India is similar to the Crown in UK, and not that of the President of US. Clear? So this was, it was a bit more complicated, but this was the question. Similarly, in 2000, I think it was in 2009, a question was asked, 8 or 9. The President of India can be the world's most powerful dictator. Comment. The question was, the President of India can be the world's most powerful dictator. So this question, these are the two questions that were asked with respect to the constitutional position of the President. Try and write it. Now try and write this question, whether you agree to this idea that the President of India can be the world's what you can say most strongest dictator or something like that. Clear? Give a next subheading, right? Discretionary powers of the President. Yes. See, as soon as the Lok Sabha dissolves, till the time Prime Minister takes the oath, the new Prime Minister takes the oath, the President is going to act in accordance to what the previous Council of Ministers, which is now the caretaker government, what they aid and advise. As soon as the new Prime Minister takes oath, now the previous Council of Ministers is no more in existence. Now we say the new Council of Ministers have been formed. Which bill?
That is passed by the Parliament.
Which bill? It depends, it depends upon what is the situation of the bill. It depends upon that. If the bill has been passed by the Rajya Sabha, it has been passed by the Rajya Sabha. So the bill, again, in that case, it does not matter. Similarly, if the bill has been passed by both the houses, so the President, the President will have to sign the bill. So in certain cases, the bill, lapses. In certain cases, the bill does not lapse. So when I come to that, then it will be very clear as to what or how will the President act. Clear? Discretionary powers of the President. So, what are the discretionary powers of the President? Have you heard about the discretionary powers of the President? Mercy petition. That is a discretionary power that the President has. No.
When there is no clear majority, he invites the higher number to make the...
Okay. When there is no clear majority, so he will invite the
person who is choose...
The political party who has the largest number of seats. So then what is the discretion there? When he has to call the political party which has the highest number of seats, so there is no discretion then.
It is not written, it is
At the time of
kind of
war,
protocol.
government.
Yes?
It is not written, but it is शुरू से ऐसे ही होता है, लेकिन binding है president के ऊपर.
It's not binding on the President. Okay. Yes.
And there is to form coalition government.
In case of a coalition government. Okay. Anything else? At the time of war. So what is the...
He has the power to for national emergency.
He has the power to?
For national emergencies.
National emergencies. He has the power. No. See, constitutionally speaking, the President has no discretionary powers. Constitutionally speaking, the President has no discretionary powers. If you get the statement in your prelims examination, which of the following are the powers or discretionary powers of the President? And there are 3 to 4 statements that are given, and one of the statement is none of the above or no discretionary power. The right answer is the President of India does not enjoy any discretionary power. Constitutionally speaking, yes. When we talk about discretionary powers of the President, any power that the President enjoys because of the situation that comes up, that is, the office enjoys some situational discretion, not constitutional discretion. The office enjoys only some situational discretion. If you look at Article 74 of the Constitution, it's very clear. there shall be a council of ministers to aid and advise the president, and such an advice can be sent for reconsideration of the president. But after such a reconsideration, if the same advice is tendered to the president, it is mandatory for the president to accept it. If the president would have enjoyed any constitutional discretion, so it would have been mentioned, there would be addition to Article 74, and it would have been mentioned there. However, in cases wherein the constitution wants the president to act in his discretion. But is it mentioned under Article 74? No. Further look at the decisions of the Supreme Court. The Supreme Court says the president cannot act without or against the advice of the Council of Ministers. There is no scope of discretionary powers that the president enjoys. Even when it comes to veto powers, veto powers that are enjoyed by the president, they are situational in nature. So suppose there is a bill that is passed by the parliament and it goes to the president for his assent, so president will not exercise veto power ki chalo man kar raha hai. That will not be the case. The president will send the bill for reconsideration or will exercise pocket veto only if he finds that there are some grounds in which he is forced to exercise that. Otherwise, why will he enjoy veto powers? Again, it is situational in nature. So yes, the veto powers that are enjoyed by the president, yes, he enjoys certain veto powers, but those veto powers that he enjoys those veto powers in practice, not in constitution, not in accordance to the constitution. Not in accordance to the constitution. Like you said, that when there is a political party or no political party enjoys majority in the Lok Sabha. But that is also situational. That will not happen always. That will not happen always. It may so happen that no political party or a coalition of party is enjoying majority in the Lok Sabha. Situational discretion. So yes, there are some discretionary powers, but these are situational in nature. Constitutionally speaking, there is no such power that the president enjoys. Clear? So for your prelims, remember, for your prelims examination, if ever a statement is asked on discretionary powers, you have to be very careful. What kind of discretion has been mentioned? If the term constitutional has been mentioned, the answer is no. However, if the term that is mentioned is for practical purposes or in situation, then he does enjoy some veto powers. What are those? Let's look at it. Clear? First, under Article 74. Under Article 74, obviously he enjoys the power to send it for reconsideration, and this reconsideration power that he enjoys under Article 74, it is a discretionary power. He does not enjoy this power according to aid and advice of the Council of Ministers. So under Article 74, first point here is under Article 74, that is the power to send an advice for reconsideration. Under Article 74, that is the power to send an advice for reconsideration of the Council of Ministers. Second, suspensive veto. Suspensive veto. Third, pocket veto. Suspensive veto. Third, pocket veto. We have already discussed what is suspensive veto and pocket veto. If you remember, I gave you an example also how when APJ Abdul Kalam was the president, he exercised his suspensive veto in Office of Profit Amendment bill. Similarly, we had talked about R. Venkat Raman, we had talked about Rajendra Prasad and even Gyani Zail Singh, who had exercised their pocket veto in some of the bills that were passed. So in these three cases also, again discretion is there. Fourth, under Article 78, the President, the Prime Minister shall inform the President about the affairs of the administration of the country and intended legislations to be passed. Constitution says that there is a duty of the Prime Minister, which means what? That means in this case the President has the right to be informed. See, what is the language? The language under Article 78 is that the President, the Prime Minister shall inform. The term that is used is shall. It's not may, ki man kiya. Now, if it's not on the discretion of the Prime Minister. The term that is used is shall. Shall inform the President of the affairs of administration as well as the intended legislations. So if there is any legislation that the government wants to pass in the Parliament, it will pre-inform the President. And this is mandatory for the Prime Minister to do. When it becomes mandatory for the Prime Minister to inform the President, it means what? It means the President enjoys the right to be informed, and this becomes his discretionary power. The President becomes the discretionary power of the President to be informed about the affairs of the administration as well as about the intended legislations. Which means what? If the Prime Minister does not do this, in that case the President may call the Prime Minister to do or to inform the President about whatever is going on. In this case he will act. Now he will act in his discretion, not in accordance to the advice, in his discretion. This is something that has been mentioned under Article 78. However, if you go by conventions, because Indian parliamentary democracy is based on the democratic system that is present in UK. So because we have adopted a similar kind of parliamentary system, so in UK the crown, that is the king or the queen that is there, they also additionally enjoy one more discretion, that is the right to warn and the right to warn as well as to encourage the Council of Ministers. The right to warn and encourage the Council of Ministers. And according to conventions that are followed in England, the President of India also enjoys, because we have adopted for a similar parliamentary form of government. So the President of India also enjoys the right to warn and encourage the Council of Ministers. So along with the right to be informed, the right to warn and the right to encourage the Council of Ministers. Clear? Write this in next paragraph. Thus, the Prime Minister has the duty. The Prime Minister has the duty to inform the President, and therefore the President enjoys the right. The President enjoys the right to be informed about the affairs of the state. In addition to this, the President enjoys, under conventions established in England, under conventions established in England, the right to warn, and the right to encourage the Council of Ministers. The right to warn and the right to encourage the Council of Ministers. Next, under Article 78 Clause C, under Article 78 Clause C. Now, what is under Article 78 Clause C? To understand this, first we will have to also understand what has been mentioned under Article 75 of the Constitution. See, Article 75 of the Constitution talks about basically two things. Article 75 of the Constitution talks about two, what you can say, principles. The first principle is individual responsibility, and the second principle is collective responsibility. Article 75 says every minister is individually responsible to the president and works in the pleasure of the president. Works in the pleasure of the president. Clear? Again, I am repeating myself. Article 75 of the Constitution says what? Article 75 of the Constitution says every minister is individually responsible to the president and works on the pleasure of the president. Pleasure of the president. Now, first of all, what is the meaning of this particular term, individually responsible to the president? It means it is the president who appoints him. Simply speaking, it is the president who appoints him and it is the president who removes him. Now, what is the meaning of the term pleasure? Pleasure of the president. Pleasure of the president means any office or any officer who works under the pleasure of the president can be removed from office at any time, at any given time by the president without proper explanations or without proper reason. Without proper reason. I can remove, the president can remove the concerned individual without any proper reason. There may not necessarily be a reason and the president may remove that particular individual. Like if we talk about Article 310 of the Constitution. Article 310 of the Constitution says that members of civil services appointed by central civil services and all India services, they work on the pleasure of the president. Which means what? You work on the pleasure of the president. When you get into service, you work on the pleasure of the president, and at any given point of time, the president can remove you. And without giving proper reasons for it. Without giving proper reasons for it. Clear? This is what is meant by pleasure principle at any given point of time. At any given point of time. Pleasure principle. For ministers, when we talk about ministers, that idea of individual responsibility actually works in this manner. The president appoints the Council of Ministers. And if suppose the Council of Ministers that are working, they are working in a manner that the Prime Minister of the country does not like. Okay, this individual, he is not working in accordance to how I want him to do or how I want him to act. So, he will ask the president or he will ask the individual minister to resign. So, give it in writing to the president. If the minister says no, I will not resign. So, the Prime Minister would advise the president, remove the concerned minister. Individually responsible, pleasure principle, at any given point of time can be removed without proper reasons. Clear? So, you must have seen that when the oath ceremony happens, so who is administering oath to the Council of Ministers? It is the president who is administering oath. Because president is administering oath, so president at any point of time can remove the concerned ministers as well. This is the idea of individual responsibility. If appointed as the minister, I am responsible, individually responsible to the president. Clear? Now, Article 75 also deals with something called a principle. The second principle that it deals with is collective responsibility. What is collective responsibility? It says that the Council of Ministers are collectively responsible to the Lok Sabha, not to the Parliament, not to the Rajya Sabha. The term that is used is Lok Sabha or lower house. The term that is used is Lok Sabha or lower house. So, Council of Ministers are collectively responsible, not individually, collectively responsible to the Lok Sabha, which means the Council of Ministers will enjoy office till the time they are enjoying the majority in the Lok Sabha. It is Rajya Sabha, they may not enjoy majority. The current Council of Ministers do not enjoy majority in the Rajya Sabha. They do not enjoy majority in the Rajya Sabha. They only enjoy majority in the Lok Sabha. Council of Ministers, how the Council of Ministers are formed? The political party or the coalition of political parties which enjoy the confidence of the Lok Sabha, the majority of the Lok Sabha, they are the ones who are appointed or they form the part of Council of Ministers. That political party or that coalition of political parties form the Council of Ministers. So, is Rajya Sabha involved? No. And hence, because Rajya Sabha has nothing to do with the formation of Council of Ministers, similarly Rajya Sabha has nothing to do with the Council of Ministers in terms of its responsibility. So, they are not responsible to the Rajya Sabha, they are only responsible, collectively responsible to the Lok Sabha. Now, what is the meaning of collective responsibility? It means if the Council of Ministers loses the trust of or the confidence of Lok Sabha, they will go out of office together. Every one of them is removed. Not that one council, one individual will enjoy office and the other has been removed. No. The Council of Ministers, if they lose the confidence of the Lok Sabha, they go out of office together. They go out of office together. They sail together, they sink together. It is said, they sail together and they sink together. And that is the reason why you will find because it is the principle on which the Council of Ministers work. It is the principle of collective responsibility. And that is the reason why you will find that any decision that is taken by the Council of Ministers, they are taken by a body called as the Cabinet. Now you will always find that Cabinet meeting is going on. After the Cabinet meeting, on 5th of August, what happened? On 5th of August, Article 370 was amended. No, it was introduced in the Rajya Sabha. It was first introduced in the Rajya Sabha, then Lok Sabha passed it. So, when this was done, what happened? How did the process start? The process started in this manner. Amit Shah first, there was a cabinet meeting. Before 11 o'clock, the time in which the parliament was scheduled to meet, before that, there was a cabinet meeting that was held. And in the cabinet meeting, all the Council of Ministers were informed that this is the decision. Do you agree? Because they work on the principle of collective responsibility, the Council of Ministers will have to agree. If they do not agree, if suppose there is one minister who does not agree to the decision of the council, so either he will have to resign or he will have to agree to the Council of Ministers. He has only this choice. He cannot say that, he will not remain in office as a Council of Minister and not agree to the decisions of the Council of Ministers. That cannot happen. And once the Council of Ministers have taken a particular decision, it becomes the responsibility of all the Council of Ministers to defend that decision, inside the Parliament and outside the Parliament. So they will not speak against the decision of the Council of Ministers. They cannot do that. If they do that, again the Prime Minister will say, the President resign karo, ya to resign karo ya hato. No, either, no, this is the choice they have. Why? Because Council of Ministers work on the principle of collective responsibility. It is very important. The principle of collective responsibility becomes very important. Why? Because so that once you see Council of Ministers agreeing to a decision, so the administration, that means the bureaucracy that is there, it will have one plan that, okay, this is the decision of the Council of Ministers and we are going to act in this particular manner. Otherwise, what is going to happen? One minister would say something else, the other minister will say something else. And there will be pull and push. And this pull and push is going to result into what? Inefficiency of administration. Why? Because administration does not know what is to be done. One minister is saying this, the other minister is saying that. So there will be pull and push within the Council of Ministers, and that will result into ineffectiveness of administration. And so that this does not happen, the collective responsibility principle is imposed. They will remain in office together, they will go out of office together. They will sail together, they will sink together. And hence, once there is a decision that is taken by the Council, that decision is to be defended by each and every member of the Council of Ministers inside and outside the Parliament. You will never see a Council of Ministers talking about, criticizing the decisions of the Council itself. Never. Example, see demonetization. Demonetization was one of the economic blunders that this particular government actually did last. Yes, you will find that there are a lot of problems that we face as of today. The economy that faces as of today, it was because of demonetization. Not all of it, but majority of it definitely. But you will never see a minister criticizing demonetization. उनके लिए अभी भी अच्छा है. Why? Collective responsibility. It is the principle of collective responsibility that dictates this. It is the principle of collective responsibility that dictates this. Clear? So, Article 75 of the Constitution says what? Article 75 of the Constitution imposes collective responsibility on the Council of Ministers. Now, because of this collective responsibility idea, what can happen? Suppose the Council of Ministers are not happy. Now, the Council of Ministers need to take an action which they know that they may not be, this action may not get the support of their own members in the Lok Sabha. So what they can do is they can bypass this idea. How? They can bypass this idea by saying that they will not call for a meeting of the Council of Ministers. There is a decision taken by an individual minister. उन्होंने बोल दिया आप ले लो, हमसे बात करने की जरूरत नहीं है. Defeat हो गया तो आपको हटा देंगे, हम बच जाएंगे. Yes, this can be done because they will say that this decision has not been collectively considered by the Council of Ministers. If the President feels that there is a decision of the individual minister which has not been collectively considered by the Council of Ministers, he can submit that decision for collective consideration of the Council of Ministers. So, though the Council of Ministers are collectively responsible to the Lok Sabha, collectively responsible to the Lok Sabha, lower house. However, if the President sees that this principle of collective responsibility is not being followed, it becomes the duty of the President to impose the principle of collective responsibility. And how does he do that? He submits a decision of the individual minister for collective consideration of the Council of Ministers, and accordingly this principle is imposed, and this is his discretionary power that has been given to it under Article 78 Clause 3. Understood this idea? Have you understood this idea? This is a discretionary power that has been given to him under Article 78 Clause 3. When I say discretionary, again you can look at it situational, only if the Council of Ministers have not considered it collectively. Otherwise there is no discretion. When Council of Ministers do not collectively consider it, only then there is a discretion that comes up. Clear? Understood this idea? Now, yes. This idea of collective. See, collective, have you understood collective responsibility? Sail together, sing together. Now, suppose we are the part of Council of Ministers. And suppose among these individuals we decide that okay, this particular decision that we have taken up, see, a Council of Ministers are responsible and accountable for the decisions that they take. Clear? So they know that if this decision is brought in the Lok Sabha and if they do not get the support of their own members, own political party, because there are some, that may happen. Some decision taken by the Council of Ministers, but they are not agreed to by their own political party. So if they decide that rather than collectively considering it, because once we collectively consider it, we have to be accountable. So to bypass this idea of accountability, if suppose one minister takes up that act, proposes it in the parliament, and if it is defeated in the Lok Sabha, rather than the Council of Ministers being accountable, they will say that only this individual was responsible for it. It bypasses the idea of collective responsibility. To ensure this does not happen, the President has the discretionary power to submit that decision to the collective consideration of the Council of Ministers. Understood this? Write this down. Under Article 78 Clause C, the President may refer an individual decision, the President may refer an individual decision of a minister for the collective consideration of Council of Ministers, so as to fulfill the principle of collective responsibility, of the Council of Ministers to the Lok Sabha, as given under Article 75 Clause 3. As given under Article 75 Clause 3. Next discretion. When no political party, you can write this, when no political party or coalition of parties enjoy majority in the Lok Sabha, then the President in his discretion can invite leader of a coalition which in his opinion is most likely to form the next Council of Ministers. Clear? See, actually by convention there is a way that this is done. First, the president is likely to ask the leader of that political party which has secured the most number of seats. If the political party declines, then the next chance is given to the coalition which was formed before elections. That this coalition which was formed before it, not after elections. Like, in Maharashtra, what has happened? It was after elections, not before elections. So the first chance is given to that coalition which was formed before elections. And they are asked, are you in a position to form the government? If no, then the president will act based on the preference. Next, what is the? But this is nowhere mentioned. It is just a convention. Hence, the president can act in his discretion. He can, he can call any political party or a coalition of political parties which according to him is likely to form the next council of ministers. Example of it was what happened in 1989. For the first time at the union level, the Congress party lost elections and there was no political party which was in majority. However, the Congress party still had the most number of seats in the Lok Sabha. But Rajiv Gandhi said that, people have voted against me and hence I am not going to form the government. I am not even going to try to form the government. So VP Singh, who was the defense minister, now VP Singh was the defense minister under Rajiv Gandhi, he resigned on Bofor's case because of Bofor. So he resigned that then, and he accused Rajiv Gandhi of corruption, etc. So VP Singh, who had contested elections differently, he got the support of the right as well as the left. So BJP also supported VP Singh and also the left parties. Okay, the left parties that are there, they also supported VP Singh, and VP Singh became the prime minister and not Rajiv Gandhi. So it is actually based on the discretion of the president. If the president feels okay, no political party, this political party is likely to enjoy more majority, likely to become the council of ministers, form the government, invite them. There is no binding that the largest political party in the Lok Sabha, they should be invited. That is not binding. Yes, by convention they are definitely asked, but it is not binding. Clear? Next. Under Article 85, the houses of the parliament should be summoned in a way that not more than 6 months lapse. Not more than 6 months lapse between two sessions of the parliament. 2 sessions of the parliament. In order to fulfill this constitutional requirement, the president may summon the house. The president may summon the houses of the parliament, even if the council of ministers do not advise him properly. Even if, see, Article 85 says there shall not be a gap of 6 months between 2 sessions of the house. So if 2 sessions of the house is held, they have to be convened in such a manner that 6 months period do not lapse. And how does the president convene both the house? If you remember, when I introduced the office of president, I said he enjoys 2 kinds of constitutional relationship, one with the council of minister and one with the parliament. And in exercise of his relationship, he will do what? He will summon the house, he will prorogue the house, he will dissolve the Lok Sabha, all these things we had discussed. So it is the president who summons both the houses of the parliament. And how does he do that? On the aid and advice of the council of ministers. But suppose it so happens that the council of ministers have not advised him properly. And Article 85 says 6 months should not lapse. So to fulfill this constitutional responsibility that he has under Article 85, he might act even without the advice of the Council of Ministers, thus becoming his discretionary powers. Clear? This is where I end today. Tomorrow when we meet, there is a discussion left here, discretionary powers, and after that I move to something called as ordinance, promulgation of ordinances or ordinance making powers of the President. With that, we complete our discussion on the President. The next topic, I'll just introduce Vice President. I'll not go into the details, and we move to the Council of Ministers. Thank you.